his speaking time with Warren Mueller, and Claude will be speaking on libel and slander. Claude, as you all know, and you should know him well, graduated from Osgoode Hall and was admitted to the bar in 1958. He's a partner with Campbell, Godfrey, and Ludis in Toronto. He's a general litigation counsel, and he's actively engaged in counsel in civil and criminal matters in all levels of courts in Ontario. He's a member of the Bar of Ontario, Alberta, and the island of St. Helena. He's presently Treasurer and Vice President-elect of the Canadian Bar Association, and Director of the Advocate Society, and a Fellow of the American College of Trial Lawyers. Claude has participated in and been a member, usually chairman, of a full spectrum of Canadian Bar Association committees. In addition to his busy practice, he is a guest lecturer at the Bar Admission course. He is a frequent lecturer at continuing legal education programs sponsored not only by this society but by the Canadian Bar Association and the Advocate Society. It gives me great pleasure to introduce to you Claude Thompson Qc.
Thank you, Bruce. Ladies and gentlemen. In the last couple of years, there has been a proliferation of defamation cases. And the courts in Canada have been looking again at the conflicting principles involved in reconciling issues of freedom of expression with freedom from verbal abuse. My associate, Ron McCloskey, and I have prepared a paper which attempts to detail some of the principles and discusses many of the more recent authorities. It's my purpose this afternoon to discuss some of those general principles with you, so that if you have occasion to refer to our paper, it may perhaps be easier for you to analyze it and decide exactly what we're getting at. I propose to start by looking at some of the standard principles of law, the standard principles and definitions which will be the basis for some of the newer authorities that I'll turn to shortly thereafter. Of course, defamation is the initial issue, and in general principles, a statement is defamatory if it degrades an individual in the eyes of his fellow citizens, exposes him to hatred, ridicule, or contempt. It's one which tends to lower a person in the esteem of his fellow men by making him think the less of him. And of course, for a defamatory statement to be actionable, it must be false. Now, what is defamatory can, of course, depend on time and place, and in particular the audience to which the alleged defamatory statement is published. For example, at one time it was considered defamatory to call someone a communist or a German. But opinions change. One wonder whether in these egalitarian times, for example, it would be defamatory to falsely call someone elitist or sexist, terms which in the eyes of some are equivalent to racist, and there's no question that that latter designation is defamatory in today's society. Now, defamation need not take the form of words alone. It includes gestures, pictures, and other acts of expression. This is of interest in light of the new Charter of Rights and Freedoms, which in Section 2 protects not only speech, but expression. Of course, the rights and freedoms listed are guaranteed, subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The onus to justify limits on that freedom would appear to be on he who purports to restrict the freedom. And thus, in my view, the section of the Charter has conspicuous ramifications for free speech cases, including defamation cases. More of that later. Of course, for a a libelous statement, to be actionable, it must be published. And every republication of the defamatory statement is a new libel. And every publisher is liable for his participation or authorization. And thus, for example, we'll find actions against the author, the editor, the printer, the publisher, and even the vendor of the magazine or paper in which the publication appears. Now, the defamatory statement may be libelous or slanderous. Simply put, written words are libel, spoken are slander. The issue is complicated, however, when the mode of expression is a radio or television broadcast, or perhaps a statue, or an action, such as burning someone in effigy. It's been said that libel is a communication permanent in form, whereas slander is more transient. And difficulties arise when one read aloud a written statement. Now, the distinction is of some importance because libel is actionable without proof of special damage, and damage is presumed. The jury may award what it considers appropriate. And slander is not actionable without proof of special damages, except where the words impute the commission of a crime, loathsome disease, or unchastity. Jurisprudence has developed around each exception, and like so much else in the law, these exceptions are growing as society moves. And for example, today there may be a question of whether or not the imputation of herpes is a slander. One question that arises is whether a plaintiff can succeed where the defamatory matter would lower his reputation among a minority group or a small segment of society only. As an example, suppose someone were to call a man a gypsy. That might not be considered defamatory among many groups of people in Ontario, but among those of Central European heritage, it may indeed be deemed especially denigrating. Mr. Justice Linden says in his book, liability is not a question of majority vote, so that if a comment would hurt the plaintiff in the estimation of a substantial and respectable minority of the community, liability may follow. If a plaintiff properly values his reputation among a certain segment of society who would think less of him, even though they might not be representatives of society, he may be successful. However, the person in society must be recognized by law as being a right-thinking person. Thus, for example, a false statement by one rogue or thief of another, he never ripped off anybody, while defamatory in rogue circles would not be actionable. Who can be defamed? Well, besides individuals, business corporations, municipalities have a reputation that the law will protect. Professional associations have sued for defamatory statements about the conduct of their affairs. Now, an area of recent development is the question of whether or not groups can sue for defamation. And the general principle is that no liability extends to the defamation of a group. And the difficulty is how one establishes that the defamation was directed at the individual plaintiff. For example, one lawyer cannot recover for the general statement, and we hope it's false, that all lawyers are thieves, because the statement would first of all not be seen as applicable to any specific lawyer, and presumably in any event would be seen as simply a generalization. The problem was illustrated in a case of Seafarers International Union, where there was a publication by a minister of the government calling the union a gang of thugs. Now, no individual member of the union could sue for the reasons we've discussed. The union itself couldn't sue because there's a statutory prohibition in the Rights of Labor Act. And so an effort was made to start the action by a member of the union in a representative capacity. And it was held by the courts that that action also failed because it wasn't appropriately a representative action, in part because each individual member might not have a cause of action. Some indeed might be thugs. And secondly, damages wouldn't be the same in the case of each member. However, there's perhaps an exception to the rule that if the class is so small, then necessarily every member of that class may have a cause of action. There's an illustration in a Quebec case in which the defendant published defamatory things about the Jewish race in general. His defense, indeed, was he intended to abuse Jewish people all over the world. But the court concluded that because there were only 75 Jewish families in the community, that the defamatory statements were capable of being defamatory about them, and accordingly, the plaintiff succeeded. Now, a statement may not be defamatory in its natural and ordinary meaning, but nevertheless, defamatory in the light of some other facts known to those who see or hear the words, so that they attach a defamatory meaning to them. In this latter situation, the statement is defamatory by innuendo. Now, an often cited example of that is an older case in which a newspaper published an account that the plaintiff in the libel action had given birth to twins. That was quite true and innocent enough, except for the fact that she'd only been married for 4 weeks. Now, the difficulties faced by practitioners commencing actions for defamation in today's society are enormous. An example is the reported case in which Premier Lougheed in Alberta sued the Canadian Broadcasting Corporation and ended up in a mass of procedural wrangle over what had to be specified in the statement of claim. The action he brought arose out of a television play entitled The Tar Sands. The play, the television program, indicated that all of the characters in the program were fictional. But people familiar with politics in Alberta thought that at least one of the characters bore a remarkable resemblance to the present premier of that province. And so he sued. And he was faced with the difficulty of trying to allege exactly what it was in the program that he thought, or indeed his friends and associates thought, identified him as one of the persons in the program who was being ridiculed in the eyes of the public. And the court apprised the general principle that says the pleading is defective because it throws, and I use that word deliberately, on the defendant a long article without picking out the part said to be defamatory. Some of the article is not defamatory of anyone at all. To throw an article of that kind at the defendants and indeed at the court without picking out the particular passages is highly justifiable. Now, of course, it's fundamental in an action for defamation that the law presumes in favor of the plaintiff that the words complained of are false. Now, that's very important. It's not for the plaintiff, as we all recall, to prove the words are false. Your case is made when you establish that the words are defamatory. At that point in time, the onus shifts, and the defendant must establish the truth, if indeed he's pleaded justification. And no action lies if the words complained of are true in substance and in fact. And this, in part, is founded on the proposition that the law doesn't allow a plaintiff to recover damages for injury to a reputation if he does or if he doesn't have one or doesn't deserve one. And this is true even if the defendant acts maliciously. And the question, therefore, arises whether it's fair and right for a defendant to defame a person by the publication of true facts maliciously, digging up, for example, an incident in someone's past, when the plaintiff today is a reformed person of good reputation. But on the present state of the law, the defendant can do just that. The defendant may try to justify only a part of the libel. If he takes the view that the statements are severable, otherwise he must justify substantially the whole, and of course the risk is that if he attempts to justify and fails, damages will be aggravated. Now, a review of the defense of absolute privilege is of interest, in that policy giving rise to that defense are based on the importance of unhindered, free discussion on certain kinds of occasions. Absolute privilege is a clear example of the common good taking precedence over private rights. On an occasion of absolute privilege, defamatory statements may be made, even if malice is present, without civil liability. Now, of course, the types of occasion accorded this absolute privilege are few. They include, most obviously, proceedings before judicial and quasi-judicial bodies, parliamentary or legislative proceedings, communications between executive officers of state in the course of their duties. The unifying principle of occasions of absolute privilege is that certain types of government and judicial business could not be carried on for the common good if those carrying out their duties were restrained by fears of liable actions. Moreover, there are other ways for the legislatures and courts to control the speech on those occasions so as to check abuses. In Ontario, the Libel and Slander Act accords by Section 4 absolute privilege as well to fair and accurate contemporaneous reports of judicial proceedings in newspapers and broadcasts. The public are entitled to be informed of court proceedings as if they were themselves present. Although the privilege is said to be absolute, there are some older cases that suggest there might be an exception. Supposing, for example, a witness in a court proceeding is testifying and volunteers something that may not be particularly relevant to the action, but is plainly defamatory. There's a case that says, if when the witness in the witness box takes advantage of his position to utter something having no reference to the cause or matter of inquiry in order to assail the character of another, such person is speaking outside his role as a witness. Qualified privilege raises important concerns, and this area has been examined in recent times. Essentially, the initial founding proposition is that if the occasion for the publication is one of qualified privilege, and there's a lot of argument as to exactly when it's an occasion of qualified privilege, but if it is, a person is entitled to publish of another an untrue, defamatory statement without liability, provided he does so honestly believing it to be true and without malice. And that is, without any indirect or improper motive. Now, the proviso designates the qualification on the privilege. Honesty of purpose is the key. The defense is grounded on grounds of public policy and convenience, said to rest on the general welfare of society. Now, what is a privileged occasion? Generally, there must be a common and corresponding duty or interest between the person who makes the statement and the person who receives it. The statement so made must be made under a duty to make it to the person to whom it is in fact made. The rationale behind the defense is the public interest that persons should be allowed to speak freely on occasion when it is their duty to speak or in their own self-interest to speak without fear of liable actions. Now, the duty we talk about may be a legal duty. Sometimes that's hard enough to decide. But also, it may be a moral duty. Now, as I say, legal duties are sometimes relatively easily ascertained, but moral duties requiring legal judicial recognition and elaboration is always a matter of contention. And the determination of what is a moral duty is, of course, a question of law for the judge. And given that there is no public consensus as to what are moral duties, it may be difficult indeed for courts to determine what people of ordinary intelligence would recognize as a moral duty, and whether there is an interest in the person receiving the communication which the court will recognize and protect is a correspondingly difficult question. An important discussion of that defense is found in the Supreme Court of Canada in a case of the Globe and Mail and John Boland. Mr. Boland was a candidate for federal office, and there were defamatory statements published about him by the Globe and Mail. The Supreme Court of Canada talks about freedom of the press in these terms. This is a judgment of Mr. Justice Cartwright, a little piece that I'd like to read to you. The freedom of the journalist is an ordinary part of the freedom of the subject. And so whatever lengths the subject in general way may go, so also may the journalist. But apart from statute law, his privilege is not other and no higher. To hold that during a federal election campaign in Canada, any defamatory statement published in the press relating to a candidate's fitness for office is to be taken as published on occasion of qualified privilege would, in my opinion, not only be contrary to the great weight of authority in England and in this country, but harmful to that common convenience and welfare of society, which Baron Park described as the underlying principle on which the rules as to qualified privilege are founded. It would mean that every man who offers himself as a candidate must be prepared to risk the loss of his reputation without redress, unless he's able to prove affirmatively that those who defamed him were actuated by express malice. And perhaps that is an important departure in the law of Canada from the law in the United States, in which persons who seek public office and present themselves on public view are subject to far more comment where malice is a necessary element before they can collect damages in a civil case. A few years ago, in 1979, the Ontario Court of Appeal had occasion to define an example of a valid social reason giving rise to the privilege in the Stopforth case. In that case, a senior civil servant had been demoted for alleged breach of duty. The minister in charge made a statement in the House explaining it, and the statement was defamatory of the civil servant. Now, of course, the statement in the House was privileged. But then the minister made a statement outside the House to the press, and because of that, the civil servant brought action. Mr. Justice Jessup for the Court of Appeal held that, of course, the statement was made on a qualified occasion because, in my opinion, the electorate, as represented by the media, has a real and bona fide interest in the demotion of a senior civil servant for an alleged dereliction of duty. It would want to know if the reasons given in the House were the real and only reasons for the demotion. The appellant had a corresponding public duty and interest in satisfying that interest of the electorate. Accordingly, there being no suggestion of malice, I would hold that the alleged defamatory statements were uttered on an occasion of qualified privilege. Of course, what's important is that the court is careful to distinguish between the duty of the minister, having regard to his ministerial responsibilities in government, and his responsibilities indeed for the civil servant in question. The responsibilities of the minister to make such a statement could be quite different for any other person in government, or indeed any other civil servant, to repeat that kind of defamatory material. In another case, a case in England and Canadian Broadcasting Corporation in 1979, the fact that an airplane had crashed in the Canadian Arctic, killing 32 people, gave rise to allegations of impropriety by the Canadian Broadcasting Corporation against the coroner. Now, in that case, the court held that the Canadian Broadcasting Corporation was not speaking on an occasion of qualified privilege when it was talking about the coroner and what the coroner had done in connection with its investigation. Because although that is a public broadcasting system, it does not have any duty to speak out as an arm of government and to speak out to the public generally, nor did the public in those circumstances have any duty to receive that information. The question of free speech and public figures arose again in another recent case, Jones and Bennett. And again, the politician was Mr. Bennett from British Columbia. The plaintiff, Jones, having refused to vacate his seat as chairman of the purchasing committee, a statutory body, was removed from his job by an act of the provincial legislature. In a speech given, the premier said, "I am not going to talk about the Jones boy. I could say a lot, but let me just assure you of this. The position taken by the government is the right position." Plaintiff brought action, and the case really turned on the question of whether or not what was said by the premier with respect to the to the chairman, the former chairman of the Government Commission, was said on an occasion of qualified privilege. Because if it was said on an occasion of qualified privilege, it's most unlikely that malice would have been found. But on appeal to the Supreme Court of Canada, Chief Justice Cartwright then said that this was not an occasion of qualified privilege, that every time a politician sees fit to give an account of his stewardship, no occasion of qualified privilege necessarily arises. And perhaps what was determinative here is that the Premier of the province chose an occasion to make his statements. First of all, when he was talking to a political gathering of members of his party, and secondly, when there were a large number of newspaper reporters and other members of the media present. Now, an aspect of qualified privilege of significance to the public generally is that which permits statements to be made in the protection of one's own interest or mutual interest. For example, if a person is a victim of an attack on his personal reputation, he may reply to the attack as if in self-defense, provided he uses only words that are reasonably necessary to refute the allegations in the original attack. Otherwise, he may be abusing the privilege. Example of a communication privileged because the defendant and recipient share a common legitimate interest would be where shareholders discuss a company's affairs or where the directors of a company discuss an employee. Similarly, a statement by a lawyer to the Law Society complaining about another lawyer's conduct would be privileged based on the mutual interest of the profession in the standards of the legal profession. Now, on an occasion of qualified privilege, the defendant is presumed to have acted in good faith and in the belief in the truth of his statements. Thus, the plaintiff has the burden of rebutting the presumption by affirmative proof of malice. Sometimes the plaintiff will say that the words themselves exhibit malice, not only are defamatory. An example is a 79 case in Silbernagen in British Columbia, where the plaintiff sued on the basis of a letter sent by an employer's association on an occasion of qualified privilege. And the plaintiff was a mechanic, but here's what the letter said about him. The letter said, "This man is absolutely incompetent as a mechanic. He hardly knows what day it is, let alone do mechanical work." Now, the defendant didn't seek to justify that. The question was whether the defense of qualified privilege, that is, a common interest in evaluating the plaintiff's competence, was lost by malice. The judge, sitting alone, had to find as a matter of law the probability of malice, then decide whether weighing the evidence there was on the balance of probability malice established. Now, as there was no evidence that the defendant did not believe that the plaintiff was incompetent, and no evidence of ulterior motive, no malice was found, and the action was dismissed. The use of the words, "he hardly knows what day it is," was held to be a mere embellishment, added for no improper purpose, and the judge refused to submit the language to a strict scrutiny in an effort to find malice. In looking at qualified privilege, of course, in our province, we have to look at Section 3 of the Libel and Slander Act, which attaches qualified privilege to a fair and accurate report in newspapers or broadcasts of certain proceedings open to the public. Of course, the failure to report all the facts or a fair summary of all the facts may lead to an inference of unfairness or inaccuracy or malice. Privilege also will extend to the headlines of an article, but only when the headline gives a fair idea of what's in the article that follows. Now, fair comment. No action for defamation will lie if the statements complained of are fair comment on a matter of public interest. This defense has as its foundation the public interest in freedom of speech. People should be able to comment freely on matters of public interest, provided they do so honestly and without malice. The burden is on the defendant to show two things: that the allegations of fact are true, and that the comment that he makes is fair. If he can show that, then the onus goes to the plaintiff to prove malice in order to defeat the defense. Essentially, that in part is to allow and encourage freedom of expression and comment on matters of political concern. And a famous English case deals with the principle this way. When a citizen is troubled by things going wrong, he should be free to write to the newspaper, in quotes. The newspaper should be free to publish his letter. It's often the only way to get things put right. The matter must, of course, be one of public interest. The writer must get his facts right, and he must honestly state his real opinion. But that being done, both he and the newspaper should be clear of any liability. They should not be deterred by fear of libel actions. Now, the Charnesky and Armdale case in 1979 in the Supreme Court of Canada considered those problems. In that case, the facts were kind of interesting because the newspaper published a letter to the editor that was written by law students who characterized the position taken by the plaintiff alderman, who was himself a lawyer, on the issue of the proposed location for a halfway house as racist. Now, the plaintiff sued the newspaper, and the action and initially the statement that he was racist was held to be defamatory. But the writers of the letter, the law students, were not sued, nor were they called as witnesses, and because they'd left the province by the time of the trial. Now, the newspapers, of course, said, we don't know whether it was true or not. As far as we know, we received a letter to the editor, and it looked all right to us, and we published it. But the newspaper's defense of fair comment failed because its editors testified they did not believe that the alderman was racist. And so there was therefore no evidence that the comment in question was the honest opinion of anybody. So this result would, I think, on first glance be seen to place an undue burden on newspapers which publish letters expressing opinions with which the newspaper perhaps doesn't agree. Mr. Justice Dixon, in a dissenting judgment, would have recognized that the law should apply an objective standard. Look at the letters and say, well, there's nothing patently unfair in that. The facts that are relied on are accurate. The comment is something that a fair-minded individual might make, and therefore the newspaper ought to be allowed to publish it. But the majority, in refining that proposition, really said that the expression fair comment is misleading. It may give you the impression that you, the jury, have to decide whether you agree with the comment, whether you think it's fair. If that were the position, the question you had to decide, you realize that the limits of freedom which the law allows would be greatly curtailed. People are entitled to hold views and to express freely on matters of public interest strong views. Views that some of you, or indeed all of you, may think are exaggerated, obstinate, or prejudiced, provided, and this is an important thing, that they are views which are honestly held. The basis of our public life is that the crank, the enthusiast, may say what he honestly thinks, just as much as a reasonable man or woman who sits on a jury. It would be a sad day for freedom of speech in this country if a jury were to apply the test of whether it agrees with the comment instead of applying the true test, was this an opinion, however exaggerated, obstinate, or prejudiced, which was honestly held by the writer. The Libel and Slander Act was amended after that case to, in effect, say that the defendant won't fail in his defense of qualified privilege in a similar action simply because the person who expressed the opinion didn't hold the opinion, if a person could honestly so hold it. But the legal principles are still applicable in similar kinds of cases, and presumably are still applicable as well, if the opinion in question is one that's published by the paper and is one of a person who's on the staff of the newspaper in question. For another illustration recently of an attempt to rely on that defense, we could look at the case of Baxter, again against the Canadian Broadcasting Corporation. In that case, there was the CBC, in a television program, said that the plaintiff, who was a provincial minister of justice, had stopped an investigation by the RCMP into alleged allegations of a Conservative Party fund and kickbacks. Now, that was clearly defamatory, and the defendant sought to justify and failed. The alternative defense was that the impugned words were fair comment on a matter of public interest. This was rejected on the basis that the words weren't comment or a statement of opinion, but were themselves incorrect statements of fact. The defendant isn't entitled to impute a specific corrupt act to a cabinet minister under the guise of comment. If the basic facts had been true, CBC would have been entitled to characterize the action as corrupt. The case demonstrates the difficulty we have in trying to run two inconsistent defenses, as happened in that case: justification, that is trying to prove the truth of all the material in the publication, and fair comment, which assumes merely that what it was as a whole was comment on matters of fact known to the public generally. Political cartoons give rise to some interesting problems. Difficulty, again, is to discern fact from comment. As you remember, you're entitled to comment provided your facts are true. The author of a cartoon presupposes on the part of the audience a certain degree of knowledge of the background facts against which the cartoon must be considered, and in light of which the cartoon makes its point. For example, a picture of the Prime Minister with his hand in the Bank of Canada may be understood to be a statement of fact that the Prime Minister is a thief, if there were no facts popularly known at the time of publication, based on which the public would recognize the cartoon as a comment on facts known to the public. An illustration is a recent case of Vandersalem, again in Vancouver, where political cartoonists for the Victoria Times depicted a British Columbia cabinet minister in a cartoon picking the wings off a fly. The cartoon was meant to criticize certain statements and policies of the minister. The minister sued, alleging the cartoon was a defamatory statement of fact, alleging that the cartoon was meant to say about him that he had a cruel and sadistic nature. The newspaper pleaded fair comment, and the trial judge rejected the defense of fair comment. And his decision illustrates part of the difficulty encountered in trying to separate fact from comment. He held the defense failed because the facts pleaded as the basis for the alleged comment, that is, the things that the minister had done in his capacity as Minister of Human Resources in that province, could not fairly lead to the imputation arising from the cartoon. Therefore, the cartoon was not objectively a fair comment upon the facts. And the Court of Appeal reversed that and said the trial judge had applied the wrong test. The test wasn't whether the comment was reasonable, but whether the view expressed was honestly held. And Chief Justice Nemitz noted that political cartoons make use of caricature, analogy, and ludicrous juxtaposition to sharpen the public view of contemporary events. Most political cartoons have inherent in their satire a tendency to lower their subject in the estimation of the public. In the circumstances of the case, the public statements of the minister provided the necessary substratum of sufficiently publicized facts to enable the ordinary reader to recognize the nexus of the cartoon and the statements. So in other words, the facts that the defendant had to establish as the basis for his comment were facts generally known to the public in British Columbia as a result of the contemporaneously published statements of the minister who was the plaintiff in the action. Now, it's clear that the cartoon, like all fair comment, must be on a matter of public interest. It remains the law that the cartoonist cannot, in the words of Chief Justice Nemitz, intrude upon the private life of a public man, no matter how interesting such an intrusion may be to the public, nor may he expose a private person to unsought publicity. The private life even of a politician is not a matter of public interest, recognized by law as a matter for fair comment. It's submitted, however, that the private life of a politician could, in principle, be a matter of public interest and therefore comment if it could be shown that his private life had public consequences or affected his ability to govern. Now, that principle has certainly dominated in the judicial thinking in the United States. In the Sullivan case, the United States Supreme Court held that a public official cannot maintain an action for defamatory falsehoods relating to his official conduct unless he can prove the statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. The court's rationale is apparently that public officials and public figures voluntarily seek publicity and thereby invite criticism and comment, and their personal lives have a public aspect. Another case of political interest, Masters and Fox, again in British Columbia. The plaintiffs were candidates in a municipal election, and the defendant said this about them. Election time is here again, with some of the same old tripes trying to get in on the action. During the past year, the Communist Party Action Committee has belched a lot of bile, and in the process, make every effort to con the people into believing they are concerned with local issues and the orderly progress of the community, when in point of fact, they are much more interested in spreading their particular band of political venom. But in spite of all, some of these loud-mouthed windbags are going to tell and show everyone how to be winners. And whatever the problem, you name it, and they'll cure it. Not one of them could run a peanut stand without a government subsidy. Now, the defense of fair comment failed in that case on the basis that the imputation was not one which a fair-minded person could draw from the facts. It might be argued that the case goes too far in favor of the plaintiffs because, of course, the candidates in question were obviously left-wing candidates. The remarks were arguably comment, albeit vitriolic, and in the circumstances of an election, the writer might have passed the test put forward by Mr. Justice Diplock that I read to you earlier, that is, that the comment could be fair, however exaggerated, obstinate, prejudiced, if honestly held by the writer. But perhaps of interest, the trial judge apparently didn't think that any fair-minded person in today's society could call a socialist one who advocated replacement of the capitalist system a communist. Now, in the Holt and Son publishing case is another case involving criticism of politicians. That case, Seema Holt, of course a member of Commons Subcommittee, during the course of her activities, interviewed Squeaky Fromm, who had, of course, attempted to assassinate President Gerald Ford. Ms. Fromm gave Mrs. Holt a message that she delivered to Charles Monson, the mass murderer. And the Vancouver Sun published an editorial that contained the following comment that was critical of Mrs. Holt. Interviewing or carrying messages for such as mass murderer Charles Monson and his groupies in U.S. jails is not what Mrs. Holt and Mrs. Reynolds are paid to be doing as members of the Commons Committee on Prisons. What they're supposed to be doing is concentrating on finding ways of improving Canada's chaotic prison system. Mrs. Holt sued for libel. She claimed that the words in the editorial, in their natural and ordinary meaning, meant that she had disregarded and neglected her duties as a member of Parliament and as a member of the Parliamentary Committee on Penitentiary Systems, and whilst in California at public expense, engaged in improper activities for her own purpose. Defense pleaded fair comment. The court was of the view that the ordinary reader would take it that Mrs. Holt had interviewed a number of persons, such as Manson and his groupies, and that she'd carried a number of messages. And of course, she had not done that. As the facts were not sufficiently stated, the editorial imputation that Mrs. Holt had disregarded her duties and at public expense engaged in improper activities was not fair, and thus the defense failed. Another publicized case in 1978, the Baltrop case, the Canadian Broadcasting Corporation defamed a distinguished physician in its radio program As It Happens. The physician gave evidence in connection with a lead poisoning case that some of us have heard about involving two smelting companies near Toronto. The plaintiff had appeared as an expert medical witness at an inquiry into lead poisoning. And the defamation was that it was alleged that he had, in effect, was a hired witness. And the statement was, Dr. Baltrop is a paid consultant to the lead industry. He is paid to say what he just said. Now, defense pleaded fair comment. The trial judge dismissed the action, found that since Dr. Baltrop admitted that he received $1,000 a day, it would be fair to say he was being paid. And what he termed the comment, that he was paid to say what he said, was fair comment. Now, in the Court of Appeal, the court held that to confine the defamation to its literally correct allegation that the doctor was paid for his opinion was to remove the sting from the broadcast and to come close to a finding the statement was justified and wasn't really defamatory at all. The Court of Appeal therefore held the thrust of the defamation was the accusation that the doctor had been intellectually dishonest and in breach of his professional duty as a physician. There have been interesting issues raised on the question of damages. One of them of interest is the Broom Case in England in 1972, where the defendants actually believed that a book they published was defamatory, but they made a business decision that the prospects of material advantage in profits outweighed the risk in damages from defamation. So although there was evidence that the defendant had been warned of the defamatory nature of the book, it took steps to market the book thereafter in paperback with a view of profiting on the sensational impact of the libel, and the plaintiff recovered punitive damages. Perhaps in that case, the plaintiff could have recovered all of the defendant's profit from publication if the action had been framed that way. The damage issues came front and center in the recent case of Monroe and Toronto Sun, the judgment I'm sure you're familiar with in recent days, a decision of Mr. Justice Holland involving John Monroe. Liability was admitted. Toronto Sun newspaper published an article suggesting John Monroe was in breach of his duty as a cabinet minister because he misused confidential information. The allegation was false. No attempt was made at trial to justify the article. What I'm most concerned about is the way in which the issue of damages was approached. The court looked to the judgments of the Supreme Court of Canada in the trilogy cases that we're familiar with in the general laws of tort involved in personal injury cases that put a cap on general damages in personal injury cases. The latter were recently dealt with in Linden and Linden, which affirmed those trilogy cases. And in that case, the court set a rough upper limit of $100,000 in damages for non-pecuniary loss, recognizing that such an award in principle cannot really compensate, but only substitute other amenities for those that have been lost. And the Ontario courts applied a judgment of Mr. Justice Diplock, who in setting aside a jury verdict in England as being unreasonably high said, "I'm convinced that it's not just that in equating incommensurables, when a man's reputation has been injured, the scale of values to be applied bears no relation whatever to the scale of values to be applied when equating those other incommensurables, money and physical injuries. I do not believe that the law today is more jealous of a man's reputation than of his life or limb. That is the scale of values of the dual." So what the judge has really done is to wipe out the principle that said initially damages in a libel action are at large for the jury, and in effect saying that the court has an overriding right to control the limit of those damages, having regard to the general proposition that damages in a libel case can't in principle possibly be higher than damages, than the non-monetary type damages, non-special damages that one has in personal injury cases. Now, the case of Vogel and the Canadian Broadcasting Corporation, again, is interesting on the question of assessment of damages. A very recent case in 1982. Mr. Vogel was a Deputy Attorney General of British Columbia, and he was defamed by the Canadian Broadcasting Corporation, and they failed in their tentative efforts to justify. And the extent of publication was particularly widespread. The court decided the allegations were neither fair nor made in good faith, and ordered damages in the amount of $100,000. And the matter of punitive damages was also reviewed, and the defendant's conduct, in the view of the court, meriting the condemnation of the court. However, the judge raised an interesting question of whether the Canadian Broadcasting Corporation, with a parliamentary grant of in excess of $5 billion, is really immune to deterrence by any conceivable monetary award, but apparently concluded that the CBC's general concern for high standards would prevail in the future, such as its corporate behavior would be affected by an award of punitive damages, which he awarded at $25,000 on top of the $100,000 general damages that I talked about. Occasionally, one is confronted with the prospect of attempting to restrain defamation before the time of publication. And there have been occasions in which interlocutory injunctions have been granted to restrain the publication of the defamatory material. An illustration of such a list is a judgment of Mr. Justice Griffiths in 1981 in the Rapp case. And he sets out the guiding principle that the injunction should only issue where the words complained of are so manifestly defamatory that any jury verdict to the contrary would be considered perverse by the Court of Appeal. Put it another way, where it is impossible to say that a reasonable jury must inevitably find the words defamatory, the injunction should not issue. In the Rapp case, the plaintiffs complained that they were libeled in the book entitled The Acquisitors, sought an interlocutory injunction restraining the defendant from publishing and distributing the book. Defendants took the position the impugned material was not defamatory. Anyway, they said it was true. The circumstances of the case, and considering the balance of convenience, that is, the books were already on the bookstore, and this, of course, is a bestseller, an injunction was not issued. But in the interest of compromise, the defendants undertook to use their best efforts to instruct each store to block out the name of the plaintiffs by black felt pen. And if you want to know what was blocked out, any of you who've read The Acquisitors, you can refer to the case, which will be found in my material. Before I finish, I did want to say something about the impact of the Charter. We've seen how freedom of expression has been limited by the common law, and libel cases are significant because the determination of the limits on speech calls of necessity for a consideration of a political principle. Section 2B of the Canadian Charter of Rights and Freedoms provides that everyone has the fundamental freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. With respect to the law of defamation, the significant freedom is that of expression. It may be argued that the law of defamation, in an unconstitutional way, restricts the right to free expression. The Charter in Section 1 guarantees the rights and freedoms set out in its subject to, and I quote, such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Of course, two questions arise. What are reasonable limits described by law? And when are those reasonable limits demonstrably justified in a free and democratic society? The phrase reasonable limits must be understood in conjunction with the meaning of a free and democratic society. The Charter indicates that the court is to take its bearings by the meaning and necessity of a free and democratic society. The limits are to be reasonable in light of that particular form of polity. Accordingly, it will be necessary to give substance to the phrase free and democratic. The question then is, how will the court approach its task? In my view, the court should consider existing laws as at least some evidence of reasonable limits on free expression on the assumption that Canada, prior to the Charter, was a free and democratic society. The courts might consider similar sections in the Canadian Bill of Rights and cases decided thereafter. Such cases will not be binding, however, given that the Charter, unlike the Canadian Bill of Rights, is entrenched in the Constitution. The courts will have to test the constitutional validity of defamation laws against the standards of the Charter. Under the Canadian Charter, the court will have to decide whether the protection of reputation demonstrably justifies a limit on free expression. You recall that's what I started with this afternoon. We have a right of freedom of expression. It's guaranteed in the Charter. Traditionally, we've put against that right a right of the citizen not to be subject to verbal abuse, or as I put it in the text this time, protection of reputation as against freedom of expression. In so doing, a court will have to ask itself whether the limit proposed is appropriate to the end pursued. If the courts do look for guidance to the existing law in the determination of reasonable limits on free expression, if the courts do not look for guidance to the existing law for such reasonable limits, the alternative will be for the court to embark on an inquiry into political science in order to decide the nature of the hypothetical free and democratic society. And I suggest that is not a desirable alternative, nor one that the judges will want to undertake. And if you can see, I turned the pages. I looked at some of those political concerns. Once the court has satisfied itself as to the meaning of a free and democratic society, and as to some possible reasonable limits on free expression, it will have to determine whether those limits are demonstrably justified. And submitted that the notion that limits be demonstrably justified means something more than that limits are generally accepted. Recent case of Federal Republic of Germany and Rocca deals with this. That was where a man was ordered extradited. He was a nationalized German citizen to stand trials for war crimes in Lithuania. And it was argued that the Charter of Rights protected him from extradition. And the Chief Justice Evans held that he had to construe the meaning of reasonable limits prescribed by law as that the party seeking to impose the limit must discharge the civil onus of demonstrating the limit was reasonable. The phrase reasonable limits imposed an objective test of validity. The question is not whether the judge agrees with the limitation, but whether he considers that there is a rational basis for it, a basis which would be regarded as being within the bounds of reason by fair-minded people accustomed to the norms of a free and democratic society. The court must decide what is a reasonable limit demonstrably justified. Criteria by which those values are to be assessed are to be found within the Charter itself, which means that the courts are entitled to look at those societies in which, as a matter of common law, freedoms and democratic rights similar to those referred to in the Charter are enjoyed. In the circumstances, Lordship held that the Extradition Act, being an act of Parliament operating in a free and democratic society, enjoyed a presumption of validity. The court should be extremely hesitant to strike it down in law unless it clearly violated the Charter. The court, and I quote, should be equally reluctant to characterize the limitation as not justified unless it is obviously unreasonable, close quote. This latter approach to the question of onus appears to conflict with the intention of the framers of the Charter. Seems to say a limitation is justifiable if it is probably reasonable. And that seems to reverse the obvious onus provision established in Section 1 in the Charter. Before leaving this topic, I'd like to refer to Section 26 of the Charter, which provides the guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of other rights or freedoms that exist in Canada. Does Section 26 recognize the rights to reputation protected by libel law so that defamation laws are intended to survive the Charter? Submitted that Section 26 authorizes the court to direct its attention in the elaboration of a free and democratic society to the state of the Canadian polity as it has existed up to the enactment of the Charter. Thank you very much.